Welcome to Pepperdine University and our conversation this afternoon of lawyering and the craft of judicial opinion writing. My name is Doug Kmiec. I am the Caruso Family Chair and Professor of Constitutional Law, and with me in conversation this afternoon is the 110th Justice of the United States Supreme Court, Associate Justice Samuel A. Alito, Jr. What's your take on the characterization of the judicial role, and in light of the way you see your own role, how does that affect the way in which you draft an opinion?
You know, I've actually given an entire speech on the issue of judges and umpires, and I'm not going to give it today because it would take up the entire time. But in defense of umpires, I have to say that their role is not as mechanical as a lot of people think. They really exercise a lot of discretion, in fact, maybe more discretion in some areas than judges should exercise. But I think what the Chief Justice was getting at was simply an analogy and not anything that he intended to be exact. Obviously, there are important differences between umpires and judges, but I think what he was getting at is a very valid point, which is that umpires have rules to apply, judges have rules to apply, and it is our job, just as it is the job of the umpire, to apply those rules, not make up new rules, and not assume a role that is broader than, different from the one that people expect us to perform, that our Constitution and our society expects us to perform.
So it's a rule-based assessment then that the Chief Justice was attempting to emphasize, that in fact you're not drafting the law, you're interpreting the law. If that is the case, how does that show up on a day-to-day basis as you're crafting opinions?
Well, let's take the issue of interpreting a statute. It was not that long ago when perhaps the most famous Court of Appeals judge in the history of the United States, learned hand, and I'm not going to get this quotation exactly correct, but the thrust of it was the best way to misinterpret a statute is to read it literally. And I think he said you shouldn't make a fortress of the dictionary. That was the dominant school of statutory interpretation not that long ago in our history. Now, I don't think that we do that in that way any longer on the Supreme Court or on the courts of appeals. We start with the language of the statute. That's the rule that we're applying, and we pay close attention to that.